Well, hello everybody. It took us a couple of minutes to organize ourselves, but now we're set and good to go. And welcome. What best way to kickstart your day and the last day of the conference with a legal philosophy topic early in the morning. And I congratulate, in a self-serving way, I congratulate you for being here because it is I browsed through the program of the conference, and we are the only panel that got 6 stars on academic and no star on business or policy. And so it makes us feel special, at least. Anyway, so welcome to the Can Law Be Determinate in an Indeterminate World panel. I am Vangelis Papakonstantinou from University of Brussels. This panel is hosted by VUB's Cyber and Data Security Lab, but this year we are not going to be talking about either cybersecurity or security in general. We are going to be talking about legal philosophy. And if you wonder what legal philosophy has to do in a technology conference, technology and law conference, then I would kindly invite you to think again, because to me at least, it is the digital element, the digital condition that has changed everything, that asks us to rethink, reevaluate and reassess, primarily from a legal philosophy perspective, what we thought we knew, what we know, and what some of us can agree on, because again, it's philosophy and nobody accepts everything by definition. So together with me to address this very interesting topic, I am glad to have good friends and excellent colleagues. And starting from the far side of our seating arrangement, Giovanni from University of Florence, Indra from University of Frankfurt, Sophie from University of Southampton, and Dara from University of Karlsruhe. And, but we will be speaking in reverse order of explaining. Therefore, the floor first goes to Dara.
Thank you, Vangelis. I thought there would be slides. I wrote slides, and I thought they would appear when I press the button. I pressed the button. Okay. Oh, there we go. Okay. So when I was thinking about the topic of this panel, I thought initially I would talk about instances in which it looked like we were witnessing some kind of reaction within legal systems which would serve some kind of legal determinacy in relation to social indeterminacy. And I was thinking about sort of what these instances could be, and as I was doing that, I came across this sort of nagging, more basic question: what is even a legal reaction which serves legal determinacy in relation to social indeterminacy? And that seemed to me to be a pretty basic question that deserved some attention. And so I thought I might try and put something together on that, and this presentation is essentially some first ideas in that direction. So before I jump into the first ideas in that direction, I want to spend a minute making a couple of clarifications. And the first is what we mean when we're talking about social indeterminacy in relation to law, or at least what I'm going to mean today. So we tend not to mean complete indeterminacy in the sense of chaos. There's really nothing in the concept of chaos that is going to allow law to organize, that's going to offer something around which the law can start to shape an image of the world. Rather, what I think we mean is that we perceive this acceleration, flexibilization, and increasing complexity of social processes. And this makes it difficult for us to order the world according to traditional classification schemes that we have, and this makes it difficult for us to understand what's happening and what's going to happen. And we have a number of sort of concepts floating around that already bundle these ideas quite nicely. One that I find particularly evocative is Manuel Castell's concept of the network society. Yeah, so essentially the same thing that happens when we try and look at the world in light of this acceleration, flexibilization, increasing complexity, happens within law as well. It becomes harder and harder for us, or hard for us, to use the existing classificatory schemes within the law to subsume the world, to understand how the law should interact with the world. And this throws up a number of questions in relation to different areas of law, and these questions exist at a number of different levels. Some examples are, how should the law subsume those? How should the world be effectively subsumed within the law? How does the law actually impact the world? So what actually happens when you release, for example, a piece of legislation into the wild? And what should the law actually be looking to do in relation to the world? How should it be looking to identify rights, interests, and come to some kind of a balance in a given situation in relation to these things? The second clarification is what we should imagine by legal determinacy when we're talking about social indeterminacy. So it seems to me to be relatively safe to say that there's some kind of link between law and society, that they exist in some kind of reflexive relationship with each other, and that developments in society are going to be somehow reflected in developments in law and in the structures of law. And in this regard, I think if we're going to presume that we live in a society of increasing complexity, flexibility, et cetera, this is going to also be reflected somehow in changes in law and legal structure. I think in that regard, one way to conceive of legal determinacy is when changes in law reacting to social indeterminacy have settled to the point where we can identify new stable patterns of legal information flows, or just stable patterns within law, then we might talk about legal determinacy. And the third clarification I want to make is that it's really difficult to predict the future. That sounds really obvious, but it's a point maybe we sometimes overlook. And this also applies to law. It's very difficult to predict the future of law, what legal systems are going to look like in the future, especially over longer time frames. And this means that a clear answer as to what legal determinacy is going to look like is difficult. The world outside the law becomes more complicated, difficult to understand, and within the law itself, we seem to witness an increasing complexity of structures and interactions. We don't always know what challenges the law is going to have to react to or will react to, or necessarily what form these reactions are exactly going to take. And that leaves us in a bit of a predicament, because it does mean that actually elaborating on what legal determinacy is going to look like in the future is very difficult. But what we might be able to do, which might be a little bit easier, is to think about a framework within which paradigmatic changes in legal structure which respond to social indeterminacy might start to be identified when they appear. And in this regard, I think we're looking for changes, or I would suggest as a first sort of impulse in this direction, that we're looking for changes which fulfill three criteria. So in the first instance, we're looking for changes which relate to stable patterns of information production in law. So we're looking for structures of law. And we're not looking for isolated legal events. We spend a lot of time looking at isolated legal events, specific court cases, new legislation, et cetera, et cetera. Now, of course, these are components which go to create structure, but they're not definitive of the structures they create themselves. That will depend on other actors in the legal system and how they use these events. Now, of course, there's a little bit of a caveat that should be mentioned here, which is that, of course, events shape structure. I mean, they're definitive in shaping structure. Events shut out whole potential structural formations that could happen. They open up spaces in which others can happen. And certain events really strongly and clearly signpost specific changes in structure. So, for example, if you insert a human right impact assessment provision in a piece of legislation, it seems very likely you're going to get a whole set of new legal information flows around that provision. So second, I think we're looking for adaptations in structure which result in novelty concerning the production of legal norms. I think there's a minor point and a major point to make in that regard. And the minor point is that it is possible, I think, to imagine changes in law which actually don't really relate to any kind of novelty in the production of legal norms. So we can imagine that a change happens at some point which offers opportunities in reaction and reacting to social indeterminacy, but actually is supplanted by another change, and yet which is retained purely formalistically in the legal system. And the second more major point is that I think we should bear in mind that there are a great many forms of possible adaptation. We spend a lot of time looking at structure, but adaptation can take myriad forms, and it might be the case that we can't even define exhaustively the range of forms that adaptation can take in advance. Adaptation can relate to changes within the legal system, so changes relating to the mode of production of legislation, the forms of substantive provisions we see, can relate to doctrinal changes, for example, in terms of the actors capable of bestowing validity on legal communications, or in relation to the relationships between areas of law. And the adaptations can also relate to aspects outside the legal system. So, for example, how the legal system incorporates and engages with other forms of information. So, for example, ethical information presumed in ostensibly ethical information production systems, how this is incorporated and taken into the law or not. And third, I think what we're looking for is changes which actually relate to problems the legal system faces as a result of social indeterminacy. And by that I mean problems which constitute obstacles for the function of the legal system relating to social indeterminacy. So, for example, if we were to come up with a broad definition of the function of the legal system, and you don't have to take this one, this is one, as a system for the production of useful norms, stabilizing expectations in other social systems, any problem for that system in performing that function caused by some aspect of social indeterminacy, that would be a problem of social indeterminacy. Now, that's a pretty nebulous concept. This concept of problems is very, very difficult to grasp. But I think maybe it can be made a little bit more digestible by breaking down this broad class of problems into three subcategories of problems. The first would be problems of limited ability for legal systems to apprehend and process the world, so to come up with relevant classifications that actually reflect what's going on. Second, the problems of limited ability for legal systems to intervene on processes in the world, so to actually engage with what's happening and have some effect. And third, and finally, problems of limited ability to revisit interpretations, so prior moments of norm production, which have been rendered invalid or suboptimal by virtue of changes in the world. So, Vangelis, I think that's it. I hope I haven't gone over my time. And
thank you very much, Dara. Normally, as moderator, I make a comment or ask a question immediately after each speaker, but I'm not going to do this today because it is legal philosophy. I will just let it sit for a while. And so I'm going to pass the floor immediately to Indra. However, please be aware that after all speakers have finished, I will give preference to questions from the audience. So please keep notes, and then immediately after everybody finishes, then I will pass the floor to you. So Indra, you're next.
Thanks a lot, and I'm probably the one who's worst on this podium because I would never consider myself a philosopher. So I will try to break some of the things that Dara said down to, this is CDP. So after all, data protection law, and where we can see some of it. And I would like to start at a different angle of what Dara just presented, and that is, I would like to start with uncertainty, which I think was on your first slide. We all live in a tremendous situation of uncertainty, and we do believe that it has increased. I would doubt that. I'm not sure whether our ancestors were in less uncertainty in their real lives. It might have been a different type of uncertainty. They might have had less black swans, they might have had less networks, they might have had less knowledge of certain outer areas which we are more aware of. So that's the starting point. We do see that there is a relation between the uncertainty in the outer world and the uncertainty in law, because law has the task to control basically the outer world to a legal sense, give structure, make revelations, organize things, create institutions. And the idea of law as such is that to construct a system of perceived certainty. And I think that's the big difference that we have to understand. Law does not create a world of certainty, but of perceived certainty in which we can act. So what we encounter is certain contradictions at a certain point where the indeterminacy of the world, or the complexity of the world, the uncertainty of the outer world, contradicts some of the findings of the legal system. And this is where we have to react, basically. This creation of the law, of a certain world of the law, is one of the major tasks of law, to an instrument to cope with that uncertainty and to integrate the dynamics. And that's where I would like to look at the instruments that we have in law and at the actors that we have in law. So going a little bit into a more differentiated conclusion to what you just presented. Let's start with the instrument, because I think that's sometimes a bit underestimated, because we tend to look at the actors in law. That is courts, that is lawmakers, etc. What are the instruments that we have that create certainty in law? The one big thing is that we use principles, that we use abstract rules, that we create institutions for interpretation. And by doing that, we structure the world. We create commercial law, we create data protection law, we create whatever type of law, criminal law. And by thus, we construe subsets of the world in law, by which we structure the outer world, by which we basically look at the outer world. The problem is that from the outer world, we always have insights into the legal system. So we are confronted continuously that the legal system we have construed is not fit to act to the challenges that are out there. So that's why commercial law doesn't answer all of the questions that are out there. That's why data protection law needs situations like these here in order to discuss what are solutions to problems that arise because technology develops, et cetera, et cetera. If we look at the GDPR, we find extremely many instruments that tries to structure on this more abstract level. The first one to say is we have the principle of technological neutrality, which is nothing but a chance to re-identify certainty in the world of data protection by creating principles which guide us, but at the same time don't tell us that it's only cloud computing, it's only data processing in the health sector, that it is consent, et cetera, et cetera. By using these examples, you can already see that they are also integrated some instruments which create a high level of specificity. Sorry about this. If we're talking about informed consent, then it's clear that we have specification what consent can do and what it cannot do, and that we are integrating continuously the outer world information. Thanks for pointing out that information is the trigger, I think, in this whole indeterminacy and uncertainty discussion. What we also experience, and that's what I think our task as lawyers is, and not so much as philosophers, again, I'm not a philosopher, is to give ideas of how to continuously restructure what is there in those abstract norms. So that's why we have legal discussions where we have one argument against the other argument, where we have interpretation standards, etc. And we're even, philosophers again, discussing what are the methodological approaches to interpretation, etc. Now, let me look at the actors. How do they create a system of coping with uncertainty? We have super stable actors. The institutions we have created, constitutional courts, courts as such, legislation, they all act according to particular rules, they all act according to particular standards, and they are acting according to a very strict time frame. And that is, in my opinion, one of the underestimated aspects of law. Law is there to stop the hustle of the world and the dynamics. We have in Germany Hartmut Rosa, who is a sociology professor, whose main thesis is that create stability in unstable systems by destabilizing these systems continuously. So by having to readapt and readapt and readapt, we create stability of the entire system. In a way, that's the exact opposite to what the law does in its institutional decision-making. We have lawmakers who need time. We have courts who consider, who listen to the parties. All of that is something which is basically taking out the dynamics of time pressure, and trying to make decisions which weigh arguments, which take their time to think, to integrate different parties, different aspects, different arguments, different perspectives, different institutions, etc. And this is something which is interesting because it totally contradicts with what we are experiencing in the outer world, with the dynamics of technology, which is one of the criticisms of modern law, basically, that it is not agile, that it is not flexible, that it is not reacting quickly. So the challenge I see is basically to trying to recombine this dynamics that we see in the outer world, the uncertainty that we see there, with the stability processes we have in law. And again, we do have a lot of instruments for that. The problem in many regards seem to be the institutions, because we have, for example, the European Court taking a decision, and that is the status quo, and it takes forever for it to change it. Agile, flexible reactions to technology look differently. That's true. At the same time, and this is something we underestimate as well, I think, we do have only so many cases going up to the European Court. So it's not as if everything is being decided there, but what we have is everyday decisions in lower court systems. And lower courts are much more flexible to change their opinion and to adapt to what's going on. And they are very often, and that's, I think, one of the advantages of the common law system, and I'm saying this coming from and being an avid friend of the continental legal system, that the common law system can react much more quickly to those actual fast developments. Same thing if you look at legislation. Legislation is meant to be slow and to take its time because it is meant to create those abstract rules which then, by interpretation, etc., can be changed fastly. And let me, because I'm sure there are a lot of private law people, I'm coming from the constitutional and administrative law section, contracts are a fantastic means to integrate this flexibility, because contracts are something which you close at a spur of the moment, and unless they're meant to last for the next 50 years because you're buying real estate or something like that, then a lot of times you can integrate in contracts clauses for remodeling, a little bit like sunset clauses in the legal system, but sunset clauses in the legislative perspective simply have not worked, so I'm not going to dwell on this. So what is it what we can do and what we have to do? And I think this is imminent when we're talking about technology regulation, because technology is a driving force, and technology in itself prizes it on being on the top of dynamics, on changing continuously. And this is a problem of GDPR, because GDPR is already 4 years old, and it's not reacting anymore to many of the technology driving forces there. What we need is basically, I think, an understanding of this interplay between creating stability and creating certainty by legal measures, and by not fighting those, I'd say, relenting moments of the legal system, but rather being open to reinterpretation, to recreation, etc. And coming from the constitutional and administrative legal side, I would like to stress that one of the big advantages that we have in law is that it creates this type of stability, that it creates expectations, and people build on these expectations. They create institutions themselves. They create, they invest. And this collision between a legally estimated and legally even furthered expectation of certainty and the changes out there is something that we have to continuously trying to combine. What we need, and I think that's where we should actually talk about, is a kind of best practice. How can we combine this stability and instability at the same time without giving away all of the advantages of creating certainty by law? And the GDPR is an example, a bad example, that it uses way too much indeterminacy and creates way too much uncertainty by using way too many abstract rules without giving examples, without giving certain guidelines. We do have them in the recitals sometimes, but they're not very specific in very many areas. We would need some technology-prone regulation, subsets, And we would need the institutions to take up much more of the flexibility that they have. So I'm addressing this at the board, at the commission, at interpretative standards, that they could give out and they could, much more flexible than the legislator or courts, change according to the needs what is there. And they could react to the pressing needs of the actual technological development. And now I hope that the philosophers will make something out of this.
Thanks, Indra. That was a call to the arms, at least that's how I heard it. But anyway, no, do something. Sophie, you're next. Oh, yeah.
Hello, everybody. I am the second non-philosopher in the room. And for full disclosure, it is true that I started in academia, but since 2018, I am now also working in industry. So this has given me a slightly different perspective, I guess, on the topic. I'm working for Immuta, which is a data governance solution, trying to show, among other things, that building global opaque data lakes is not a fatality. And for complete full disclosure, I'm going to tell you that I was not entirely sure where to start the discussion, but I'll try to say a few things, which might be a little bit provocative in some places, but I'll try my best to capture my ideas on the topic. Okay, so the question that I'm trying to answer is whether indeterminacy is undermining the GDPR. And so, assuming that works, is this working? And so, to answer that question, obviously, we need to define terms. And as I said, as I'm not the philosopher, then I need to open my dictionary. And that is one definition that I found, the state of not being exactly known, established, or defined. And I suppose in that context, the adverb exactly is actually quite important. Why? Because indeterminacy is usually, at least as a first intuition, the state of the law, isn't it? So to try to answer that question, then what I've seen is that people usually go back to the distinction between hard versus easy cases, and to go back to the books and the textbooks, and the definition of an easy case is the following. An easy case is one in which the facts of the case fits the core of the pertinent concept words of the rule in question, with the results that the application of the rule is obvious and unproblematic. And so the assumption is here that if you have easy cases, then you have determinacy. And so what do we have with the GDPR? Well, if I look at the GDPR from the practitioner perspective, or some would say from a compliance perspective, what do I find? Well, I find some easy cases, yeah? If you look at the provisions about recording of processing activities, data minimization, let's say, purpose limitation, do I process the data that I need for my purpose? Do I describe and correctly describe my processing activities in my privacy policies or notices? Do I mention the data points I actually mentioned in Article 13 or 14? And then I also have something about transfer. I've put that in the list of easy cases. It might not be the case, but if you look at at least from the perspective of the recipient of the Grande decisions, one quick question is whether you are transferring in plain text data to a third country for which there is no adequacy decision, and that triggers a series of compliance requirements. So in fact, from that perspective, there are not that many. Just stopping here. They like the easy cases, yeah. There are not that many hard cases, are they? Well, I've obviously oversimplified a little bit the picture. Transfer, obviously, the cases in relation to international transfer could be classified as hard cases. Beyond the political and moral questions that these types of cases actually raise, there is a degree of complexity built into the assessment. It's not only whether you actually transfer plain text data to a third country for which there is no adequacy decision. If that's the case, then there is also a risk assessment according to recent guidance that should be done. So you need to understand how you do that, and you need to understand actually what a risk assessment really is. That being said, if you look at, again, at recent decisions, then you see that there is consensus on how transfer should be actually looked at, and what the results of the assessment should be. So is indeterminacy really the problem here? Usually behind that concept, there is a broader concern. If the law is indeterminate, the law is not predictable, and above all, judges are not constrained by the law when they decide. So the question that I'm asking is this really a GDPR problem? And by this, I'm wondering whether this is unique to GDPR or not, and whether this is really that problem that is undermining the framework. If we rewind a little bit and look at the criticism that have been put forward against GDPR, what do we find? Some have argued that GDPR is not fit for purpose. Well, why? Because one argument is that the rules are actually bad for all. They are not good for innovation, and that's because the GDPR is based on outdated principles, such as data minimization and purpose limitation. These principles do not work in a data-driven world. That was the claim, at least at the beginning of the negotiation, and that has continued after that. Is this, what kind of problem is this? To me, that sounds more like a determinacy problem than anything else. And actually, if you look at recent evolution, what you find is that these principles are emerging in other frameworks, such as CPRA in California. Another type of argument is that the rules are bad for the small ones. This is also related to innovation. We should draw a distinction between the big ones, who have the resources to build compliance programs, and the smaller ones, who should not be concerned too much about compliance with the GDPR, because they don't have the resources, and because complying with GDPR is resource intensive. What kind of problem is this? To me, again, that's a determinacy problem. That's a clear choice that has been made by the EU legislator. Others have looked at the problem differently. Again, if you look at CPRA, what you are going to find is that they draw a distinction. They have a threshold built into the framework. They start from the assumption that if you are small, then you should not be concerned about that. Now, if we want to go back to GDPR, the things are a little bit more nuanced, actually. There is some acknowledgement that SMEs and small businesses are not exactly in the same position as bigger companies. And if you look at also the requirements for recording of processing activities, you will see a distinction. What needs to be reminded, though, is that if you adopt, let's say, a constructive approach to GDPR, you will see that, for example, in Article 5, you've got some key principles, but they work like as goals. Yeah? They are not telling you exactly how you should do minimization in a specific use case. So when you look at these principles, obviously you need to look at the overall context and strike the decision taking into account a variety of factors. So not big and small organizations are not going to be definitely in the same position. And the fact is that if you think about these principles at a very early stage, you're obviously much better placed afterwards when you grow to be able then to comply. So it's not completely, let's say, stupid to start from that assumption. And if you look also at the position of the actual EU startups, what you find is that they do acknowledge that GDPR has had a positive impact, even if they also argue that we need to do more to be able to then sustain innovation on that basis, and in particular, we need to enforce the rules against the big tech companies. Not everyone agrees, obviously. I work, obviously, in a jurisdiction in which they need to draw differences and distinguish themselves. So we shall see what is actually, where this actually goes. Again, the driver behind the attempt to reform GDPR is innovation. I think the word innovation is cited like 70 times in the document. They want to come up with a framework that is business friendly, and for that purpose are trying to see how the framework can be slightly amended. But again, saying that the GDPR is too restrictive is not saying that there is too much uncertainty. There are determinacy problems, and I acknowledge them, but this is not necessarily saying either that the whole framework is unfit for purpose. Then there are another type of criticism, which is the rules are interpreted inconsistently across member states. And here I've picked one in relation to anonymization and pseudonymization, so I've been working on that topic for quite some time. The fact that we have different interpretations on the topic does not necessarily mean that there is an indeterminacy problem, I would argue. The law is in the making. We have some standards. Some member states have more restrictive standards than others, in particular France, in that regard, is more absolutist than others, and for sure is more absolutist than what we had actually in the UK. Obviously, the UK is now out of the EU, but for sure, if you look at the way they understand anonymization, they have, people say, a very pragmatic approach to anonymization. They take into account the organizational measures that are being applied on the data on top of the technical measures applied on the data, and that means that therefore sharing becomes much easier. So data with indirect identifiers are being shared as anonymized data because they take into account the trust environment. Whether that's a better rule for innovation, here we can argue, but the claim here is that it's not necessarily, well, the problem is more about having multi standards than anything else, and the hope is that, well, there will be some convergence, and this is why we are all waiting for the new opinion on anonymization techniques that should be released by the end of the year. Another way to look at the problem is that the indeterminacy is only temporary, if you think about, obviously, the role of the Court of Justice here. Then there is obviously the argument that the rules are confusing. Which legal basis should I use? This I hear all the time. What does it mean to delete and to anonymize? These are the questions that I'm getting constantly. But here again, I would argue that it's not so much that the rules are confusing, is that they require some ponderation before implementation. So they are resource intensive. That's the true answer. If you don't want to accept that, then you will run into the rule directly. So I'm not entirely sure that here again there is really an indeterminacy problem. This is true though. Again, there are some divergences. If you look at what others have been doing in that space to try to simplify the framework. They don't have that distinction between legal basis and purposes, legitimate purposes. They've tried to simplify the framework, but what does that mean? That means that it's much easier to share data under that framework than it is under our framework. So it's not always shiny, also over there as well. And then finally, the rules are not enforced properly, which seems to be one big problem, which is being described in a recent article on the topic, and which with a very catchy title, explaining how actually GDPR is failing. Why GDPR is failing is because GDPR is not able to tackle the big tech problem. My first reaction reading this was actually that the title was too catchy. The problem is I think it's much bigger than that. And this is where, if you read a bit of philosophy and if you actually try to engage with what Stigler has been saying about the current world, then you start to understand that we are in a very, yes, indeed, complex situation, which can, and the story could potentially turn very badly for us. His point is that the disruption that has been created by the technology that we have today has destabilized the economic and social structure that is sitting on top of what he called tertiary retention or memory, if that's, I'm not entirely sure how this is being translated in English. So it's a whole societal problem that we have to deal with that goes beyond GDPR and big tech as we usually define. But beyond the catchy title, what we have, obviously, in that article is that there is clearly an enforcement problem. How is this explained? Well, the main claim is that the regulators are not acting. Is this, again, an indeterminacy problem? Why are they not acting? And here, the focus is being put on the one-stop shop process that is not exactly functioning very well, in particular because most of the cases are going to Ireland, and here, over there, we can observe some delays. There is not reaction is not as immediate as we want it to be. So here, yes, there is space to argue. There is space to try to see how we can improve the framework. The framework has been built in a certain way. That was not the way it was built before GDPR, so it's relatively actually new in the way it is built today. Asking for a framework of that type to be perfectly functioning after 4 years, it might be quite a high expectation. But again, is this really an indeterminacy problem? I'm not sure. And just to conclude, I would say that, at least to me, the problem is more about lethargy than anything else. Up until now, the GDPR has been one of the very few legal instruments that has been used to fight the disruption that Stigler speaks about. We are getting more instruments now with what the European Commission has been doing with the Digital Services Act package. So we shall see what happens. I'd like to be a bit more optimistic than others.
Thank you, Sophie. Thank you very much. And now, Giovanni, it's your turn.
Okay, so thank you very much. I hope it works. I don't know. I should have some slides, but let us see. Okay, perfect. So, I go back. Okay, so I invented a new word, techno-pragmatics and the determination of the law. So,
Giovanni, the microphone.
Sorry.
No, it's on.
It's on, okay. As a philosopher, okay, very well on. So, this is my question that I'm going to try to answer. Is there any specific in the kind of indeterminacy that we have in the domain of technology law? So clearly, information technology law and GDPR can be indeterminate. We may have terms that are ambiguous in their meaning. For instance, what is a legitimate interest? Is any permissible interest, or is some interest that is somehow encouraged or protected by the law? We may have vague terms that may not be applied to certain items. So, for instance, we had for a long time the doubt whether certain kind of online identifiers were or were not personal data. That was then removed by the GDPR. But maybe there is also some other issues which are somehow specific to technology law. So, obviously, we have to take into account the context in which a law was enacted, the context in which a law is going to be applied to determine the meaning of the legal provision, the GDPR, for instance. But there is also something more that goes on. Let us consider an example. As we know, personal data means any information related to identify or identifiable natural person. But we may interpret this rule by trying to figure out what identify or identifiable means, and then we have the recitals that can help us in this regard. But once we have read the recitals and we have understood the concept, it's not finished because we need to do something more. So we need to determine whether some items of information are identifiable, are connectable to a particular individual. We also have to consider what are the technologicals that are available, what kind of advantages and costs are available for re-identification, what is their cost and practicability, and on this basis we can determine whether a certain item of information is or is not identifiable. So to determine whether a concept, a notion, a term that we have interpreted applies or not, we need to engage in a kind of empirical technosocial analysis. And this is, you can also look at the notion of personal data, how it is presented in the GDPR. Again, we have this notion of identifiability, which is not sufficient to determine whether a certain item is identifiable or not, and because even if the concepts remain constant somehow, as technologies develop, the scope, we say the extension, the items to which the idea of identifiability applies changes. For instance, thanks to AI, data which were not identifiable have become identifiable. Let me go on and maybe show you another example. Consider the idea of necessity. For instance, as you can find in Article 6, processing is necessary for the performance of a contract to which the data subject is party or in order to take steps, etc., etc. What does necessary mean? And secondly, how do we determine what is necessary? What is involved? So we may have an issue of interpretation, but we need to go beyond interpretation, beyond determining the meaning of the concept of necessity, in order to determine whether a particular kind of processing is necessary or not in order to perform a contract. We have to, that is first an issue of, I think, disambiguation. Does necessary mean that without this processing no performance is possible? Maybe too strong. Does necessary mean that without this processing the most efficient performance is impossible? Maybe too weak. Maybe some balancing is needed, so the performance, necessary performance must be sufficiently efficient, but not excessively affect the data subject. And then once that we have set up for it, for a concept of necessity, is not finished. because we must know also how much a particular processing contributes to the achievement to a successful performance, and also what kind of problems it causes to data subject. And this is empirical information that is not included in the legal document. We may also, maximum indeterminacy, meaning, I would say, in the GDPR. Consider again, go to Article 7, F, where we have the issue of, where we have the concept of legitimate interest, where there is balancing which is involved. Obviously, again, also here we need some pragmatic enrichment at the level of interpretation. We need to wonder what purpose is qualified as legitimate, what qualifies as a right or an interest of the permissible interest, or maybe non-permissible interest. Also, what is here we have a kind of ambiguity in the law. Then, what does it mean to how can we engage in balancing? So we have some ambiguity, vagueness, but then this is not finished. Because to determine whether processing fits the condition on Article 6F, we also have to wonder some empirical, again, inquiry. What interest exists in a given situation? To what extent the processing is going to affect this interest? Which set of interest prevails? So there is this kind of, I would say, techno-social empirical analysis that is required in order to apply the law. And you can find it again when you have a kind of best effort obligation. Consider, for instance, the case of Article 25, data protection. We have that the controller has to take into account the state of the art, etc., the risks, and implement appropriate technical and organizational measures, so to achieve data protection by design by default. Again, there is an issue of interpretation, but this is not just interpretation. To determine whether this provision has been applied, we must know what risks exist and what technical and organizational measures are appropriate. Again, we need to interpret what appropriate means, but this is not enough. We need to know what are the, how much a certain technology contributes to the purposes of the processing, what costs and side effects they have. So this kind of techno-social knowledge is needed in order to apply GDPR, at least when GDPR provisions are expressed in the particular way that I have just mentioned. So there is a kind of sharing of the cognitive effort that is required in order to apply this kind of provision. A part of it was done by the legislator when setting up the GDPR. An effort is required by the interpreter when giving meaning to the GDPR provision, and here we have all the baggage of legal interpretation, the canons, the arguments, the way to enrich the content of legislative expression by relying on the context in which they were enacted, the context in which they have to be applied. But again, this is not enough. There is also the need to determine, to engage in this kind of techno-social analysis, determining what are the impacts of particular processing operations, both their contribution to the legitimate purposes which has been aimed at, and also the side effect they may have on data subject. And we may wonder whether it is okay to delegate this kind of techno-social specification to the addressees. To have the controllers in first stage to determine what counts as personal data, what is legitimate when a processing achieves legitimate interest without unduly burdening the data subjects, when a processing is appropriate. Obviously, the advantage is the dynamical adaptation to techno-social change, because even if the concepts remain the same, the way in which they are applied is dependent on technological opportunities. And there are also, I would say, kind of modal notions. This is also a philosophical term in the sense that in order to determine what is again, appropriate, what fits the interest. You have to consider not only what is happening, but also what alternatives are available. And this kind of investigation of possibilities, according to the current technological affordances, is needed. And this raises prediction on cost problems, even for well-intended addressees. So individuals, on the one hand, they have to engage in this assessment, or companies, but they have also to anticipate how the competent authorities are going to engage in the same kind of assessment, involving, for instance, identifiability or appropriateness or the achievement of legitimate interest. There are costs involved in getting the needed expertise, and there is also a high risk of mistake divergences, which may lead to sanctions and other negative consequences. So the issue that I think we need to address, if this kind of indeterminacy that does not concern, I would say, interpretation, but concerns more the application under given techno-social conditions, has to be maintained. It is not possible to remove it at the source through more precise legislative or regulations, or at the legislative or at the regulatory level. How can we handle that? And I think a key issue that we need to address is what kind of legal guidance can best be provided at the application level. And I think that access to advice from authorities would, even anticipatory advice, would reduce compliance cost. And interaction and also the adaptation of sanctions to uncertainty would also contribute to, I think, reduce this issue, and we need to design a kind of ecology for compliance adaptation that takes these risks into account. So, thank you very much for your patience. I think I stop here.
Thank you, Giovanni. Thank you very much. I would like to thank the speakers for presenting their arguments and different opinions in such a good manner, and I think we made good progress. There is still time left, and now I open the floor to you. Yes.
Thank you for the presentations. I'm not a philosopher. I'm Alessandro Mantelero. Sorry, not a philosopher. I'm very interested by this topic on indeterminacy. When I attended the panel, it was not so clear to me what was the goal. And I think that the link that Indra make between the indeterminacy and the agile was interesting from my perspective, because there are different solutions that you can imagine. I think the system is not so rigid, but I think that we need, of course, a system. And I think that there are three main solutions that already we see in the GDPR and also in the AI Act. The first one is the administrative interpretation. The role Article 29 working party, more than the ADPB, that provide interpretation, although were not binding, but shape a lot the interpretation of the law. The second point is the co-regulation that was not mentioned, but is a bottom-up approach that provides a lot of flexibility to the system. And the third point is the AI Act that refers to the Commission and gives to the Commission the power to identify the new high-risk category. I have personal opinion about these three solutions. I'm scared about one of these three in terms of balance of power between the different powers. But I would like to know what you think about this solution that can provide flexibility, but also in a different constitutional / legal context. Thank you.
I think that was addressed at me, and thanks a lot for picking up on it and actually in this round agreeing with me. There are lots more a lot more instruments, I think, to name. One most important one is burden of proof, and not just in court, but also in argumentation, etc. So I fully agree that this is a means. The problem is, and this is where indeterminacy and uncertainty come into the legal system by itself also, that is complexity. And complexity, if it was all easy, A to B relationship, then we wouldn't have these discussions naturally. So what we have to take into account, and I fully agree there too, is that by establishing certain instruments, you also influence the system as such. So and I mean, this was one of the big discussions in the GDPR, because the Commission originally wanted to have the power to really reenact a lot of different aspects and gave the power exclusively to itself. And this was something which the member states didn't like very much. So they actually argued in favor, and this is what came through, for a lot of more determinate interpretation, at the same time trying to rely on a very, very abstract level. And the balancing of power argument is one that goes very much to, I think, the bottom of it, because this creates, and this is something that we didn't talk about yet, is that uncertainty is perceived, or indeterminacy is perceived very differently, of course, depending on the background you have. An expert might find a situation totally clear and understandable, and will find that the legal regulation is perfectly set, while someone who is dealing with the situation for the first time will find it extremely indeterminate and difficult to understand. And this relates to the institutional power game, which is much more than a power game, but it's also an interaction. And we see that with the European Data Protection Board, for example. How much power are they taking? How much are they distributing? How much are they leaving with the local DPAs, et cetera, et cetera. So because it's such a complex system, I think there is a lot of legal uncertainty as well. And the only thing we can do is basically look at it closely, control for it, and trying to react continuously. And this is one of the instruments which I find are totally underestimated, and that is monitoring. What we see right now, for example, with the sunset legislation, is that the legislator finds out, oh, it's 4 months before the law will fall apart. Well, if you're lucky, then they have a big discussion on it, but in the end, the result is always the same. We don't really do anything. And we just continue what we've done, which I don't think is monitoring. Monitoring is that you go in circles and that you really continuously change, and you also change legislation, etc. And so completely agree, long list of instruments, lots of indeterminacy and lots of interdependencies there.
Yeah, thank you for the question. I don't want to directly address it, but what I notice is when we talk about these mechanisms of addressing indeterminacy, we're often talking about the content, but we rarely talk about what these mechanisms in sort of their modern, or in this case, data protection manifestations, do in relation to how we understand the legal system and legal information flows. So for example, for me, the Article 29 Working Party and the EDPB are fascinating, but not because of what they say. I mean, also that, of course, but because if you look at the structure of data protection, or if you want to find out what that is, if you ask, I don't know, anybody writing on data protection law or practicing lawyers, they'll say, well, there's the GDPR, there are CJU judgments, and there's the EDPB guidance. The EDPB is an executive authority. This is not traditionally part of our understanding of the interpretation of valid law, defining what the law is. And you could say, okay, this is an adaptation which is fine. We need more moments at which norms can be produced, because we simply have this great requirement for interpretation and clarity, and there aren't going to be more courts in the foreseeable future, and the courts that we have aren't going to produce more interpretations. But you can go a step further and say the information that they produce is not the same form of information that's produced by courts. And one example, and there are other ways in which I think this is also true, is that the structure of information is very different. They don't follow the argumentative protocols, they don't follow the sort of headings the courts use. If you read a court decision, it relates to a specific case, and it works through the case legally. If you read the EDPB's guidance, say, for example, you can compare cases on consent, EDPB guidance, court, you're reading what essentially reads like an academic commentary. That's very different. I don't know what the consequence of that is in terms of the possibilities this opens up for law, or the problems this opens up for law, but to my mind, the consequences and problems, they're not non-existent. We just don't know what they are yet. Yeah, thank you.
Maybe just a small comment. Following what I said before, I think that it is interesting the kind of guidance that, for instance, the Article 29 working group has been providing. So sometimes you get also quite a lot of empirical information from their opinions. And then on this basis, some kind of normative indication are expressed. So I think they provide input to the parties, not just about the interpretation of the GDPR, but also about what kind of processes are going to impact on the relevant impacts or the interests and make a technological difference, for instance, with regard to the issue of the identifiability of data subjects in their opinion on personal data. So there is this kind of mixture that even their expertise, I would say, on the technical, practical side can provide guidance to the addressees that are engaged exactly in this kind of assessment.
Any other question?
No, just to add one tiny point. So I've tried to simplify. I'm not denying the complexity of the framework, and certainly not the normative complexity that is there. What I would like to insist on is the iteration that needs to happen and the dialogue that needs to happen between the different sides, which is essential and which is needed. This is the only way we are going to go forward, and the cruciality of being able to speak different languages and bridge the gap between the legal and the technical, as Giovanni mentioned. In 5 minutes, I'm going to speak about homomorphic encryption. This is very painful. I have got a legal background, but if I don't do that, then I'm not understanding what the challenges are, even if, unfortunately, I will obviously make some mistakes in the way I present things, but if we are not forcing ourselves to try to communicate with the other side as much as we can, then we are not going to find a way to implement the framework.
Can I suggest that instead of talking about indeterminacy, we talk in terms of the law about underdeterminacy. And that means the law, of course, is aimed to provide closure, but the specific thing about the law is before providing closure, it initiates debates. And the use of natural language, we're now on the verge of introducing computer code, data-driven systems into the law itself. So that may be an interesting moment to stand still at the fact that we have natural language, which has inherent open texture, which is not the same as ambiguity, but will often produce ambiguity. And my point would be that that is a feature, not a bug, and that it also slows down the closure. So there is first the closure of the legislature, and we have decided, and that's the rule of law, that the legislature is not allowed to determine the meaning of its own legislation. Many people don't realize this, but that is the rule of law. So the entity that issues rules doesn't get to decide in concrete situations what it means. Why? Because that's open to arbitrary decision-making. Now, this basically produces a certain slowness. And I think, again, when Indra Speaker was speaking, I tweeted that my conclusion from what he was saying is that the slowness of the law is a feature and not a bug. And I'm not saying that we have to prolong uncertainty and that the idea of what qualifies as anonymization and what as pseudonymization and what is the role of state-of-the-art economic feasibility, that these things don't have to be decided at a certain point. But I am saying it's very important that they're not decided for once and for all, precisely because of the technological developments, and that this slowness is something we should cherish without, once again, being naive about it and saying we don't need closure.
Yes, thank you very much, Mireille. If you allow me, I'm going to use Mireille's comments as a closing remark of this panel, because it's also related to closure, and we have time constraints. So I think that we can use the slowness also recommendation and release you to a well-deserved coffee break after this strong early morning protein dose of legal philosophy. Then sounds good to go to continue with CPDP. I would like to thank everybody, the speakers, the audience, for being here with us, and see you in the next panels of CPDP. Thank you very much.